say ye in the Indians go for by, the South of Far for Eddie Abba, or my Ghana with the Sawapam and your summer would walk pan, and Memodia, and ye. To me, in yin in the news and for no in Sincha the Birada. And today, be a make subscribe to your channel no. Also, all other relevant news are and can for politics one, any governance, any idea. Say for political parties, NPP, NDC, CPP, PDP, and other political parties, no so. Osabeka won se mo ha ede na asesi bio a ama atumpan ana ama yenya asundwe e wo sete domasi yenkotie nsem bi emra pedefo ase ka kom jeje no kofo enum nti mentumi nkansam nso mfa nhye nkofo bia no yenkotie mra na ye ba ye de adwenche ba hwese wutie no no comment nso bi gu ase na bibia nso aye kama ne atuma nya bre akenkan e de ama before that nso no subscribe to your channel no on Sabeka all other relevant news yetie se memra sisi a na ye ba ye de the akabia and so atwa so na bibia nso aye wana yenti mercy ya.
Starting with issues regarding the legal fraternity, because barely 24 hours after petitioning the Criminal Investigations Department to investigate Justice Yoni Kulendi and Richard Jakpa over alleged interference of administration of justice, Daniel Mafu Oforiata, a Chebi indigene, has escalated the matter to the presidency. This time, he is asking President John Mahama to remove Justice Yoni Kulendi as a Supreme Court judge, accusing him of improper interference with a trial involving Dr. Kaisala Tuforson and two others. Lord Eduasare reports.
The war of petitions began with businessman Richard Jakpa, who was the second accused in the ambulance trial. Together with Dr. Kaisala Tuforson and Sylvester Animana, they were facing charges of causing financial loss to the state. In July, Richard Jakpa petitioned the CID to investigate the former Attorney General Godfrey Yeboah-Dame, accusing the latter of soliciting his cooperation to testify in a manner which would incriminate Dr. Kaisala Tuforson, the first accused. He attached WhatsApp conversations between the two of them as evidence to make his case. Few months on, private citizen Daniel Mafu Oforiata also petitioned the CID to investigate Justice Yoni Kulendi and Richard Jakpa over allegations of interfering with administration of justice. The petitioner alleged that Richard Jakpa, with the help of his cousin, Justice Kulendi, sought to obstruct justice by pressuring Godfrey Dame to discontinue the prosecution against the businessman. Oforiata further alleged that, upon failing to do so, Richard Jakpa went on a spree seeking to tarnish the image of the former Attorney General. In a petition dated September 30 addressed to President Mahama, Daniel Mafu Oforiata outlined 4 grounds for removal against Justice Yoni Kulendi, including alleged ethical violations. He attached the cross-examination of Richard Jakpa by the Attorney General in the ambulance trial, WhatsApp conversations between Richard Jakpa and the former AG, the High Court ruling, as well as other court documents to buttress his point. It remains to be seen if the President will act on the petition by Daniel Mafu Oforiata. Lord Dwasari, TV3 News, Accra.
Fresh Chance now available.
Right, let's get some legal perspectives on this. Martin Pebu is a private legal practitioner. He's joined us for a quick chat on this. Counsel, good evening. Thank you for your time.
Yeah, good evening, man.
Right, to start with, we're told, clearly looks like Article 146 has come back into mainstream conversation. This time around, it's a Supreme Court judge whom the president has been petitioned to remove. But on the face of it, as a lawyer, what are your initial thoughts and the grounds on which this petition has been sent to the president? It is interference with judicial process. What do you make of it?
Yeah, so the first thing is that the Supreme Court has warned time ad nauseam, endlessly, that the petition should not be published. Should not, it's not even should, must not be published. You say, so it's actually a bit, let me say, retrogressive, that despite many Supreme Court decisions, still these petitions keep leaking and being published. You say, because with that, it affects the process. That's how come that the Supreme Court said no, when a petition is made in a J2 versus Attorney General, the Supreme Court said the only thing that should be said is that the petitioner can announce to the media that, yes, I filed a petition. I'm not suggesting that it's the petitioner who leaked this petition, no. But what I mean is that under the law, the Supreme Court says that the petitioner can inform the media, the general public, that he's filed a petition. That's it, but not the content. And so neither the petitioner nor any citizen, right, has a right to publish the petition. So in order for us to mitigate the effect of what has already been done, maybe we would not discuss the merits, so that at least we would see that as already been published, it's been published already, so it's not our fault. But if we were to go into the merits, then it will be seen as a fresh step that we are now prejudging the matter.
Certainly.
But what I can also say is that the next point I wish to make is that, well, it tells you that citizens are beginning to assert themselves more and more, because this matter was in the public domain last year. We beat it many times on the key points and other TV3 programs, and we saw how it showed that the Attorney General was involved in unethical conduct, etc. Right? But now that the petitioner has chosen to take on Justice Kulendi, it also means that once we're condemning the Attorney General, it's not within our right to just condemn the petitioner. Let him have his day in court. That's before whether before the Council of State, whether he succeeds beyond that point or not. Let's just simply say that he should have his day in court.
Right. And Council, clearly it's an issue of concern, and like you indicated, the petition was supposed to have gone straight to the president, but the full details of it is already in the media. So it's subject to what many have described as, public courts to discuss and talk about it even before the presidency acts on it. But does that have any bearing on at all on the final outcome, if any, when the public speaks about an issue?
No. What the Supreme Court said in the Justice Paul Berry versus Attorney General, Chief Justice Tiger P.I., etc., was that they cannot cancel the petition. They cannot throw it out just because it has been leaked. In the same manner in the Justice in the Petition case, that was the same thing. The Supreme Court said they can't throw out the petition just because it's been leaked. So that won't have a bearing. But maybe if the leaker, the person who leaked it, is caught, then perhaps there will be the full extent of the law will be brought to bear on him.
Right. Okay. And finally, still on the same strand of conversation having to do with Atuforsen's case, we know that the General Legal Counsel has also been petitioned to take action against former Attorney General Godfred Dame. He has responded to it. We'll bring the response to our viewers in a bit. But before you leave us, what are your general thoughts on his response to the fact that the General Legal Counsel is being asked to look into his conduct, having spoken to Richard Jakpa in the build-up to the case that was in court?
So the same comment as I gave for the Article 146 proceedings. So now, when a lawyer is also facing disciplinary hearings, it's also supposed to be in camera. That's Regulation 15 of the the professional ethical rules, right? The disciplinary rules. So we enjoy the in-camera hearing. So for that reason, we cannot discuss the merits of his response. And so we'll have to wait for the disciplinary committee to come out. So once again, we'll commend the petitioner for taking that bold step. That is what we need citizens to do, to hold duty bearers to account, because we know we're all not happy with the way Godfred Dame conducted himself in that office as Attorney General. He lowered that office to the lowest the extent that we've ever seen in this republic. And so it's good that he'll be facing the disciplinary committee. Yes. Okay. But as to the merits, we will express no opinion.
We'll hold on for now. Thank you so much, Martin Pebu, for your time. He's a private legal practitioner.
Great new possibility.
Godfrey Adame, former Attorney General, Justice Yoni Kulendi, Supreme Court Judge, and Richard Jakpa, currently the Director of Operations at the National Security Council. Richard Jakpa has led many of the operations that has excited the NDC base, going to people's homes, arresting them, etc., etc. Now, Richard Jakpa has sent a petition to the CID, asking the commissioner in charge of the CID to look at what he calls Godfrey Dame's purported interference in that forcing case. What was the purported interference? Purported interference was that a meeting was convened for the two gentlemen by the Supreme Court's very distinguished Supreme Court Judge, Justice Yoni Kulendi, in his home to try and resolve matters between the parties. Apparently, Mr. Dame responded to this because of course, everyone respects Justice Kulendi. And so he responded because of Justice Kulendi's stature and personal relationship with him. Now, though, Richard Jakpa is asking the CID to do more than the High Court did. The High Court looked at the matter and gave a ruling on it. I'm sure we'll give you that as well. But the big story is that whilst Jakpa has sent that petition, another person, Mr. Daniel Oforiatta, says that no. Whilst Richard Jakpa has sent the petition, he believes that the CID should actually be looking at the conduct of Mr. Jakpa and the Supreme Court judge. Now, here is the petition sent by Daniel Mafo Oforiatta. They call him DM Oforiatta. It is written to the Director General Criminal Investigations Department in Accra. It says, "Dear Madam, request to investigate His Lordship Justice Yoni Kulendi and Richard Jakpa for conspiring to interfere with the administration of justice. It is as follows. I hope this reaches you in good spirits," he says. "I am a citizen of the Republic of Ghana with keen interest in the development of the rule of law, good governance, and democracy. In January 2023, the Republic of Ghana commenced a prosecution of accused persons in a case bearing the title Republic versus Kesela Tuforsen and two others. Richard Jakpa, the current Director of Operations at the National Security Council, who was dishonorably released from the Ghana Armed Forces in November 2007 for unsatisfactory conduct and failure to pass his examinations, was a third accused. The said Richard Jakpa, as Daniel writes, as subsequently became obvious from the proceedings, is the cousin of Justice Yoni Kulendi, a Supreme Court judge." It goes on. In the course of the trial, it was revealed that right from the first day the accused persons were arraigned before the court, 18 January 2023, Richard Jakpa deployed the highly influential Justice of the Supreme Court, Yoni Kulendi, to obstruct the course of justice in the case with the ultimate object of ensuring that the prosecution of Richard Jakpa was either abated by the then Attorney General Godfrey Adame or he, Jakpa, was acquitted. The acts of Justice Kulendi and Richard Jakpa border on the commission of crimes relating to interference with legal proceedings. The following facts, evidence of which I will produce, bear this out. 1. From the proceedings of the trial, on the 18th of January 2022, after Richard Jakpa had been arraigned in court, he solicited the help of his cousin, Justice Yoni Kulendi, to procure the assistance of the then Attorney General to facilitate the release of Richard Jakpa when he had not satisfied the conditions of the bail granted to him. Justice Kulendi actually went to the office of the former Attorney General Godfrey Adame to request that his cousin be permitted to go home. At the trial, under cross-examination by the Director of Public Prosecutions, Richard Jakpa confessed to obtaining the telephone number of Attorney General Godfrey Adame from Justice Yoni Kulendi, after which he confidently attempted to meet with Mr. Dame and inundated him with many WhatsApp messages. All these were tendered in evidence at the trial on the 18th of June 2024. It is on record that Mr. Dame refused Richard Jakpa's invitation to meet with him. The evidence shows that from the time Richard Jakpa first got in touch with the Attorney General Godfrey Adame via WhatsApp, he sent in all 68 WhatsApp messages to him, in reply to which the then Attorney General sent only 2. 68. But what was the content of those 68 messages? That's a lot of messages to send to an Attorney General. 68. Really? Is there anyone that you have sent 68 messages to? I can't think of anyone that I have sent 68 messages to, unless you're looking at over a year or 2 years or something like that. 68. 111 up to 68. Wow. Okay. Well, Mr. Daniel Oforiatta will prove this when he's called.
Happy Sunshine Education.
Messages to him, in reply to which the then Attorney General sent only 2. Richard Jakpa confirmed this under cross-examination by the Director of Public Prosecutions, Mrs. Yvonne Atakra Obuobisa. Really? Okay. Furthermore, it is undisputable that when Mr. Dami turned down Richard Jakpa's overtures to meet him, Justice Yoni Kulendi, in breach of the code regulating his work as a superior court judge, lured the then Attorney General into meetings at his, Justice Kulendi's residence, on no less than 4 occasions. Justice Kulendi will then secretly invite Richard Jakpa to come over to his house and interfere in the legal proceedings pending against Jakpa by impressing upon Mr. Dami to stop the prosecution of the former or ensure that the prosecution will let him go free at the submission of no case stage of the trial. This is borne out by the record of proceedings at the trial. Indeed, the record showed that apart from inside the courtroom and the house of Justice Kulendi, Mr. Dami never met Mr. Richard Jakpa anywhere. The above, madam, shows a calculated effort by the learned justice of the Supreme Court, Mr. Justice Yoni Kulendi, together with his cousin Richard Jakpa, to interfere in the prosecution of the criminal case filed against Richard Jakpa by the Republic of Ghana. This is not only dishonorable, but also borders on the commission of crimes in accordance with the Criminal Code and Offences Act 1960, Act 29. His request, according to Mr. Daniel Fori, to the CID is as follows. He says, I respectfully request you to conduct an investigation into the conduct of Justice Yoni Kulendi and his cousin Richard Jakpa, to unravel all acts of criminality disclosed by their conduct and take such prosecutorial action as is consistent with the law. I am available and willing to assist you with any documents, including relevant exhibits and the record of proceedings in the Republic versus Case Lato Forsen and 2 others, which you cannot access. In the meantime, attached to this petition are 1. Copies of the WhatsApp communication between Richard Jakpa and the Attorney General Godfred Yeboah Dami. 2. Record of proceedings in the trial of the case Republic versus Case Lato Forsen and 2 others dated 6 June 2024. 3. Record of proceedings in the trial of the case Republic versus Case Lato Forsen and 2 others dated 18 June 2024. 4. Record of proceedings in the trial of the case Republic versus Case Lato Forsen and 2 others dated 20th June 2024. 5. Record of proceedings in the trial of the case of the Republic versus Case Lato Forsen and 2 others dated 27 June 2024. 6. Hope the matters raised herein will be thoroughly investigated in accordance with due process. Yours faithfully, signed, Daniel Mafo Oforiata. So this matter is not going away anytime soon. I was on the same touch screen here last year in the heat of elections that we had to analyze the Richard Jakpa and the Attorney General matter. As you may know, the matter started at the High Court in the prosecution of causing financial loss to the states in the case of the ambulance. Case Lato Forsen was being questioned about an LC that he had approved and a contract he had approved without the approval of Parliament, or that Parliament had approved the contract in a certain way and he was executing it in another way. This is what he was accused of. The trial went on quite acrimonious, a lot of conversations here and there. Good Evening Ghana got involved, who were lambasted, attacked, all kinds of things. My friend Samuel Jamefi, at that time, he was the communications director of the National Democratic Congress, held press conferences after the court trial. It was a big deal. There were many interested parties, business interests, political interests, judicial interests. It was a really big trial. At the end of the case of the prosecution, the case Lato Forsen and all the others made a submission of no case. Those who understand criminal procedure understand it. There's not much time for me to go into it, but they made a submission of no case, that the prosecution had refused to make a case against them, that they had not been able to make a case against them. This is what they said. And then the High Court ruled that they had a case to answer, so case Lato Forsen had opened his defense. But then he had filed